Always good.
Okay, very good. Okay, so let me see. So similar to international law is going to be four modules. Okay, so what I'll do is I'll take you through what is contained in the four modules. The first one is probably I think probably the most detailed of the excuse me, in some ways the most detailed and the most information of the four, because it kind of comes in two halves. So the first half of module one covers off the sources of Irish law. Okay, so I think again, if you stop somebody in the street and said, okay, where do our laws come from? The first answer you probably get quickly enough would be that somebody would say, well, they're created in the Dáil and then they're signed off. You know, they pass through the Seanad and then they're signed off by the president. And yes, that is one of the ways that we get our laws in Ireland. But there's a number of others as well. The decisions in the courts has a bearing on our laws as well. Okay, so we're going to cover that off in the notes. The Irish Constitution definitely determines where some of our laws come from, and then also the European Union plays a big part in the laws that we have in this country. Okay, so there's the European Union, statutory legislation, which is the stuff that goes through the Dáil, the Irish Constitution, and then the courts. Those are the four areas where we see. Those are the four areas where we get our laws from. Okay. So let me see. So we're going to cover those off. So we're going to explain each of them in detail. Okay, how all of that works. We're going to talk about the legal profession and the people that work in the legal profession. Okay, we're going to talk to you about the role of the Attorney General, the role of the Director of Public Prosecutions. We're going to talk to you about what solicitors do. So solicitors are essentially client facing. So they deal with, if you have a legal issue, it tends to be a solicitor you go and see. The solicitor will then work with the barrister, and the barrister is more often than not the person who stands up in court and either pushes for your side of the argument is probably the best way of doing it. If you ever watch kind of legal stuff on television, I suppose the most likely stuff that you may have seen would be obviously criminal law, but that's not the only type of law that you have. A lot of it is not criminal at all. There is contract law, the law of tort, which is basically when accidents take place, or tort basically means a wrong. There's commercial law disputes that will end up in the courts, and there's obviously employment law. Okay, all of them from time to time you will see on the news. Okay, and there are differences between them. Okay, again, if you're watching TV, you may be familiar with the expression beyond reasonable doubt, which takes place in criminal cases, and yes, that is genuinely the way it happens. But there's also civil law as well, where a judge can potentially rule, kind of say, right, well, I'm really down the middle on it, but I'm going 51% in favor of one side and 49% in favor of the other. So therefore, the person on the party on the 51% wins. Okay, so beyond reasonable doubt is not a requirement in all cases. Okay, so we will take you through all of that. We will also take you through damages. Okay, or the remedies. Actually, the remedies is a better expression. The remedies that you can have at the end of a court case. So obviously in a criminal case, one potential option that the judge has in front of them is to imprison the person who is found guilty. But obviously things like fines, community service, and binding to the peace, which basically means they promise to behave themselves for the next X number of years. Those are obviously options in the criminal cases. In the civil cases, obviously nobody is going to go into prison unless they have broken an actual law. But the things that could be awarded are damages, injunctions, which will force the parties to complete. Injunctions which will stop a person from doing whatever it is that the plaintiff, who is the person taking the case, doesn't want to happen. There is specific performance of a contract, which will mean that somebody, usually the defendant in a case, will have to go ahead and complete the painting of the house or the year's worth of work or whatever it is that the court case has been taken for. And then finally, there's what is known as rescission of a contract, where the judge will take a look and says, this is a crazy contract. It should never have been signed. And therefore, they will allow the two parties to basically tear up the contract and walk away from it. Okay. So that just gives you an insight as to the stuff in the first, that's all in the first half of module one. What we have in the second half of module one is contract law, which is a very interesting area. Okay, it's basically, it'll show you how to put a contract, it'll show you the requirements that you will need to enforce a contract, okay, of which there are 4. Okay, so if you want to create a contract, you need 4 things. You need an offer. Okay, so I put an ad in the paper, or I give you a phone call and I say, okay, do you want to buy my car? You need acceptance. Okay, so you need somebody to reply back by email, by phone, by letter. In some way, they need to reply back, say, yes, Paul, I would like to buy your car. So that is known as acceptance. So you have an offer, then you have acceptance. You need consideration. Okay, so you need something to change hands. Okay, that's usually money, but not always. Okay, so you say, yes, Paul, I would like to buy your car. How much is it going to be? I say 10,000, and you say, okay, fine, I will give you 10,000 euro to buy your car. Okay, if there's no money changing hands, it's not a contract. It's potentially a gift. Okay, and gifts can be taken back a lot more easily than contracts. So if there's a contract and if there's offer, there's acceptance, there's consideration, which normally means money, you're on the way to creating a contract. The fourth and final thing that you need for a valid contract is you need what is known as intention to create legal relations. Okay, so if we're having a discussion about you buying my car and it's on a nightclub in Leeson Street at 4 in the morning, the chances of that being legally binding are much less likely than if I say take an ad out, or I put an ad up on the internet and say car for sale, please reply in writing and so on, and I look for that. If I'm looking for things in writing, looking for emails and things like that, it's far more likely I'm serious about selling the car than if it's merely a discussion in a nightclub at 4 o'clock in the morning. So there is the fourth and final thing is intention to create legal relations. And the contract law is going to be your first assignment. Again, a number of weeks down the track, but it will be your first assignment is on contract law. So that's all in module 1. There's a fair bit in there. Any questions on any of that before we move on to module 2? No, okay. So module 2 is on the area of company law. Okay, so we've done the sources of Irish law, we have done contract law, we're now moving into company law. Okay, so the first thing we cover off there is what are the sources of company law, and the majority, in contract law, a lot of the law comes from the court cases. Okay, one court case follows another. Okay, the judge looks at what happened in a previous case and says, yeah, that looks exactly the same to me. I think that seemed to be a sensible decision, and they follow it. Okay, in company law, it's a bit different. A lot of it comes from actual statutes. Okay, so these are things that would have been signed into law by the government. Okay, in some cases quite some time ago, in other cases a bit more recently. I mean, the two statutes that are the key drivers these days of company law are the 1963 Companies Act, and then more recently the 2014 Companies Act. Okay, so what they cover off is they cover off things like, okay, what sort of reporting needs to be done. Okay, I mean, a number of years ago, Ireland was not seen as maybe the most, we were talking in the international module about things like the country risk and so on. Ireland was not seen as necessarily the best country in the world to do business in, because there were an awful lot of companies that were kind of created which were maybe not doing an awful lot of reporting or under reporting and things like that and so on. So a lot of that changed in the last kind of 20, 30 years. So there are reporting requirements that you must fulfill, regardless of whether you're a small company, a medium company, or a large company. The requirements get bigger as you get as become a bigger and bigger company, but there are reporting requirements nonetheless. Okay, and the reason that that's useful to you in your credit, in the role of either credit or collections, is it means if a company starts going overdue, you can start saying, okay, let's have a look at your books. Okay, we're a bit worried that maybe you don't have any money, or you're losing money now. Let's have a look at your books, and they are required to provide it to you. Okay, all right. So if you ask for it, they're required to give it to you. So we cover that off. Okay. We cover off things like the Company Registration Office. Okay, so the Company Registration Office is basically a database of all of the companies that exist in the country. Okay, so that's where you register the company name, and if you're changing the name, if the officers that are in charge of the company are changing, that's where you make the amendments. We cover off the Office of the Director of Corporate Enforcement. Okay, so their job is to make sure that everybody running a company complies with a certain number of rules. So again, from time to time, these things pop up either in the newspapers or on the or on the 9 o'clock news. So I mean, you will, when you finish this course, you will have a better understanding as to why it is that that there is a problem, or why it is that somebody has broken the law when they're doing things, or why there's a legal dispute. So the Office of the Director of Corporate Enforcement, that is another thing we cover off. And we also cover off a number of things at the end of the life of a company, or I suppose towards the end of the life of a company, when things are going pretty wrong. We cover some details as to how liquidations happen. Okay. On the legal side of that, we also look at examinerships. Okay, so we will cover that off as well. Okay, so examinership is where the court steps in and awards protection to a company to allow it to try to trade its way out of trouble. Okay, for the benefit of among other things, the employees. And then we also have a section on receiverships as well. Okay, receiverships being a scenario whereby if a company falls into financial hardship, there may be the option of a creditor to go in and take an asset belonging to the company and use that to discharge the debt. And then the final thing that we look at, which is certainly relevant depending on your role, that we look at in Module 2 is the Consumer Credit Act. Okay, those are the rules by which you can offer credit. Okay, so you need to be, if you ever watch an ad on TV for a financial services business, you know, there will always be an awful lot of writing, small writing, usually in white, which will pop up while the ad is running. And if it's a radio ad, they will probably say at the end, you know, these rules are governed by the central bank and in compliance with the Consumer Credit Act, or they will say some format of that. And that is not there just for the fun of it. It is there in order to ensure that they are compliant with the Consumer Credit Act of 1995. So company law is what we cover off in Module 2. Any questions on that? No, lovely. And we're doing well on time, so we're all good. Now, if I can find Module 3, I'll be good. There's Module 3. No, that is International Module 3. Sorry, bear with me a second. There we are. There's the law one. Okay. So in Module 3, a couple of things we cover off. We start off Module 3 by kind of, I suppose, going a little bit back towards the contract law of things, because we talk about sale of goods, we talk about imports and exports. Okay, so we do cover that off, and I suppose a couple of key terms that come up when you're talking about sale of goods is one, fitness for purpose. Okay, so that's where you buy, you know, if you're buying something, if you're buying a car, for instance, it needs to actually run. And then there's also discussion around what is known in Latin as caveat emptor, which is let the buyer beware. Okay, so those are a couple of things that come up at the beginning of Module 3, but the majority of Module 3 is around EU law. Okay, so I mentioned at the beginning that we get our laws from a number of different places. The European Union is one of them. Okay. The European Union essentially guarantees, there's about 4 or 5 different things that the European Union essentially guarantees. One is free movement of goods. So you should be able to move your goods relatively freely throughout the European Union, the same way you can move them relatively freely around Ireland. There should be free movement of workers. So obviously, if I live in Dublin and I decide I've had enough of Dublin, I want to move to Galway, I can obviously do that without kind of getting any visas or right to work papers or things like that. It should be relatively similar if you're moving from Ireland to France. Okay. There should be free movement of services, the right of establishment. Okay, so you should be able to set up companies fairly easily within the European Union. There shouldn't be any undue things that are thrown in your way. And then there's also free movement of capital. Okay, so these are basic rights that the European Union protects, and the reason that it was founded to begin with. Okay, and we'll go through. I'm not going to go through it now, but in the notes we are going to go through the history of the European Union and the number of treaties that have brought us to where we are now. Some of which you may remember being voted on a while back. We haven't had a referendum on it in a while, but you may remember them from like me from your younger days. So let me see. So we're going to talk about the community institutions. Okay, we're going to talk about the European Commission. Okay, who essentially do an awful lot of the strategic direction of the European Union. We're going to talk about the Council of Ministers, okay, who are essentially responsible for implementing the direction that the Commission is looking for going. So they meet every 6 months. Okay, there's the European Parliament. Okay, so similar to our own Parliament, except an awful lot bigger. Okay, there's kind of 500, 600 odd people in there. So it's a very, very big Parliament. But that is one of the European institutions. Okay, And we're also going to talk about the European Court of Justice. Okay, so I mean, in module 1, we go through what the Supreme Court is. I forgot to say this, but we go through the Supreme Court, the High Court, the Court of Criminal Appeal, the District Court, the Circuit Court. We go through all those in module 1. The European Court of Justice is kind of the, I suppose, the last port of call in relation to any legal challenges you want to take, and it does have to actually be related to what you see as being a breach of one of the fundamental rights of the European Union. So you can't just rock up to the European Court of Justice and say, I don't like the decision because of X, Y, Z. It needs to actually relate to saying it infringes on my free movement of my free movement of goods or something like that. Okay. And we're also going to cover off the sources of European law. There's two different sources. There's the primary sources and the secondary sources. The primary sources are basically the treaties which have been signed over the years, which have brought us to where we are now in terms of a structure for the European Union. The secondary source of law that we have in Europe are things like regulations and directives. Regulations are basically like laws. They are binding on their entirety onto people. And then there are things like directives. Directives, a good example of a directive would be the European Union wants us to cut a certain amount of greenhouse gas, but we will leave it up to you whether or not you do it by doing something in agriculture, doing something on industry, doing something to speed up the electrification of your cars or whatever it may be. So directives will say, this is where we want to get to, this is when we want to get to it, but we'll leave it up to you in the individual country as to how you achieve those targets. Okay. So module 3, a little bit on the Sale of Goods Act, but mainly European law. Any questions on that? Okay. Declan is amazed that I'm on time for once. I suppose being way behind, but okay. So module 4 is on tort. Okay, so our last module is on tort, and tort has to deal with wrongs. Okay, so and I suppose if I just explain that a little bit more, it kind of basically comes down to accidents. Okay, something has gone wrong. Nobody really wanted it to go wrong, but it has gone wrong. And as a result, some damage has been incurred. Okay, so in the law of tort, there's 4 things you're looking out for. In contract, there's 4 things as well. You're looking out for your offer, acceptance, consideration, and intention for legal relations. There's 4 different things in tort. You are looking out for a duty of care. Okay, so you have a duty of care to people that you are interacting with. Okay, if I'm close to you, I have a duty of care not to do anything that may injure you. You need to have a breach of the duty. The example that I always gave when we used to do this in when we used to do this in an actual lecture theatre is, you know, I have a duty to you. If you're sitting 10 feet away from me, I have a duty not to do anything to hurt you. Let's say I start throwing my laptop around and flinging it around the room. Am I breaching that duty? Yes, I am. Okay. All right. So you have a duty of care. You need to have a breach of the duty. You need to have damages. Okay. All right, so something needs to go wrong. If I throw the laptop around, but I don't hit you, then that is not necessarily, I haven't necessarily committed a tort. If I throw the laptop around and hits you in the head and you have a cut over your eye as a result, then yes, you have incurred some damage and you could certainly sue me for a tort, okay? And then the final thing that you need in order to prove a successful action in tort is you need a causal connection between the two, okay? So if I'm throwing the laptop around and I hit you and you have a cut above your eye, that's one thing. But then if you die of a heart attack a year later, you may have a more difficult job on your hands. Well, your surviving family members may have a more difficult job on their hands convincing that there is some relationship to me throwing the laptop around in February 2023 and you dying of a heart attack a year later. Okay, so you need to have a connection between the two. Okay, so we'll cover all that off in module 4. The most relevant part of module 4 that connects most closely to any work that you may do in particularly credit is there is such a thing known as negligence misstatement. Okay, so if for argument's sake you rely on a credit reference, let's say you go and look for a credit reference. Okay, so you say, right, I'm going to do business with this company. I want to be sure that they are good for the 10,000 that I'm going to lend them. And you go and look for a credit reference, and somebody writes a credit reference for your customer and says, yes, I think this person is going to be good for 10K, and here's why I think it, and so on. And then then you end up losing your 10K. You may potentially, it depends on the circumstance, but you may potentially have a case in what is known as negligent misstatement. Okay, if the person has really messed up and didn't really conduct any due diligence and just wrote the piece and said, well, yeah, they're good for 10K, but they did nothing to kind of check as to whether or not they were good for 10K, you may potentially have a case of negligent misstatement. And your second case, your first assignment is on contract law, but your second assignment is on negligent misstatement, okay, which comes under the area of torts, okay? And then the last thing we cover off in module 4 is what is known as occupier's liability. So what is the duty that you owe to people who come onto your land or come into your building? Okay, are do you have, in some cases, you have duties to remove all possible things that they could trip over and hurt themselves on. In other cases, you may be sufficient in just not intentionally hurting them. So it comes under a number of different categories. There's recreational users, there's visitors, and there's trespassers. You have certain different duties to them depending on what classification the person who comes into your building or onto your land has. Okay. And that concludes module 4, and with it, the course.
It all sounds so simple, Paul, when you're just going through it like that. I think it's best summed up in the phrase "introduction to law," and I think what the course, I hope, gives you, and it certainly gave me when I studied it, just to give you an understanding and appreciation for the law. A lot of us have visions of what it is and what it does, and I think certainly from module 1 and the sources of law, I think it gives a great insight into a country, because at the end of the day, the laws that we sign up for, that's what defines a nation. So to know how the law works and how the country works, that's good. I think from a credit management perspective, to know what a contract is and how a contract is created and the elements of a contract. So anybody who's doing this course, I sort of say to them, look, you mightn't have all the answers at the end of it. You will have some intelligent questions. And I suppose that's really what the whole thing is about. So it's about asking and about looking at things in a different way when you understand what it all means. And certainly in terms of tort, in terms of when a wrong is committed. So from a credit management perspective, in terms of sharing information and legal liability and all that kind of stuff, because a lot of the compliance and regulatory stuff falls into the credit department. So we need to kind of be aware of what's going on in the world. So to me, it's an interesting subject. There are a number of cases that will define, particularly in the area of contract law, you'll see there'll be different cases cited that will define the law in these particular areas. Take the time to read them carefully, because sometimes you see two cases that look very similar and have different outcomes, and just understanding the difference between them is where you define the law. So it's very, very logical thinking, which is probably alien to some people. So that's what it's all about. There's a fair bit of reading in it. We keep the Latin to a minimum. Again, obviously there are Latin phrases that are essential, that you have to know what the phrases are, but just it gives you, I think, an overall understanding of the law. And I know this is something that you studied in a previous life as well, Paul, so it is an area of particular expertise for yourself, but it is almost a language unto itself, isn't it?
Yeah, it is. There's no doubt about it. Yeah, no, you're right. The Latin phrases are thankfully kept to a minimum in these notes. But yeah, when you do the whole thing, there's a fair bit more of them.
Yeah, but again, it's just picking out the essential things, and bearing in mind that it's not a legal course, it's a credit course.
Yeah.
So it's to keep it as practical as possible for the people who are there. So guys, we're not going to keep you unnecessarily. I will stop the recording now, just because we can.